Mark Stevens, author of Adventures in Legal Land and host of the No State Project, the only show on the air dedicated to bringing about a voluntary society. You can hear that every Saturday afternoon from 5 to 7 p.m. Central Time and 2 to 4 p.m. Pacific Time on We the People Radio Network. That's WTPRN.com. And that's WTPRN.com. What I want to talk about today, civil traffic tickets, beating civil traffic tickets, getting them kicked out. The thing I want to point out, though, is all traffic courts, it doesn't matter who or what, who's running them, they're all scams. It's nothing to do about protection. It's nothing to do about justice. It's about separating you from your money. That's all they're there to do. And you'll find that out if you are unfortunate enough to have to go there. You see, most people, their interaction with government is through traffic tickets. We all know somebody who's got a traffic ticket. Nobody wants to get it. And what they do is they set the fine low enough so that you'll just pay it. They go, oh, this isn't worth my time. I'm not going to take time off from work. It's only a couple $100. I'll just pay it. That's a mind game. They're doing this on purpose. It's part of the whole advertising and public relations of these con men called traffic courts. They want you to just pay it because if more people fought it, the whole system would collapse. Either that or before it collapsed, what they would do is they would keep lowering the fines. And they would keep lowering the fines until they got that happy medium to where people would just pay it, which is, of course, what they want. I mean, why go through the whole charade of trial if you just have people send the money in? I wouldn't just pay it because as I'm going to go through here, and it's not some conspiracy theory crap, okay, you can verify all this. You'll see that no traffic ticket has any validity whatsoever. They're just part of a scam. So it doesn't matter what they're actually accusing me of, the ticket has no validity whatsoever, even under their little codes. So what I talk about a lot is the issue of standing, and this is just one of many ways of showing that a traffic ticket has no validity, but it's a big one. It's a very important one. If I can show that the plaintiff has no standing to complain against me, well, then the court has no subject matter jurisdiction, and the case has to be thrown out. It doesn't matter what I'm being actually accused of if they can't show standing. So this is why I press this issue so much. It's a very big issue. Again, it's only one of many issues that show that traffic tickets are just part of a larger scam, and that they have no validity whatsoever. So one of the things I want to point out, that if you learn anything from the video, is that a ticket, let's say a ticket, is not synonymous with a complaint, with a cause of action. See, they want you to believe that a cause of action and a ticket are exactly the same thing because then they've already won. They've got you here. Because, most people just assume, there's a valid cause of action here. I'll pay it. Or it's not worth my time. I pay it. But boy, you open up a whole can of worms now when you start questioning whether the complaint presents a valid cause of action. And a cause of action is a very specific thing legally. In fact, any attorney will tell you that. They don't want you to discuss that. The one thing that judges and prosecutors and especially police, they don't want you talking about cause of action or standing. And they'll even let you think that doesn't even apply. We'll show you that it does. So before we get into the issue of standing, to determine how somebody gets standing in an American court, you have to know what the court is for. I mean, why do we have courts? Why do we have government? Now, I know this is all public relations, but this just goes to show that the ticket has no validity, even under their little code. You find the purpose of government in the Declaration of Independence in most state constitutions. In Arizona, for example, it's Article 2, Section 2, and it states that governments are established to protect and maintain individual rights. Okay, now, stop laughing. So the governments are established to protect and maintain individual rights. So this is why we have the government. Now, we know courts are part of the government. So the purpose of the court is to protect and maintain individual rights, of course. So what is the court's jurisdiction? Well, the court's jurisdiction is limited, of course, to its purpose. The purpose is to protect and maintain individual rights. So the jurisdiction of any court is going to be limited to the protection and maintenance of individual rights. That's basic common sense. So then for a plaintiff to have standing in that same court, in an American court, the plaintiff has to allege the violation of a legal right because the court's jurisdiction is based on protecting and maintaining individual rights. So to have standing, they have to allege that. And you can go into any number of court cases. They're consistent, believe it or not, with this. Of course, they don't like to hear this in a traffic court. Raines versus Byrd, Standing is a necessary component of subject matter jurisdiction. Well, you have to have subject matter jurisdiction even in a traffic case. It states that standing is perhaps the most important of the jurisdictional doctrines. Standing represents a jurisdictional requirement which remains open to review at all stages of litigation. And then the Supreme Court of the United States again, Allen versus Wright. This is where you get into the elements of standing. The requirement of standing, however, has a core component derived directly from the Constitution. A plaintiff must allege personal injury fairly traceable to the defendant's allegedly unlawful conduct and likely to be redressed by the requested relief. So you have to have the injury, which is the invasion of legal right. So we know that they're claiming that it's a civil traffic ticket. Let's say I didn't have a seatbelt on and they filed a civil action against me. Well, did they allege the violation of a legal right? Is there any injury? It says, again, they must allege personal injury. Well, was the police officer alleging personal injury? Does the prosecutor allege personal injury of the so-called plaintiff? No. So now if the courts, now this is subject matter jurisdiction, so for a plaintiff to have standing, they have to allege the violation of a legal right. Once they do that, then the court can have subject matter jurisdiction. But here we see there is no violation of a legal right, so there couldn't be any subject matter jurisdiction because the court is limited, and the purpose of the court is to what? That's right, to protect and maintain individual rights. So you see right off the bat, no driver's license or no seatbelt or even speeding. Not that I'm advocating people traveling in at a speed that's not reasonable or prudent, but 5, 10, 12 miles an hour over the speed limit probably isn't really endangering anybody. So you see that there's no validity whatsoever to any of those tickets, and that's on just this one issue alone. And if you think that this isn't a serious issue, that the government attorneys don't take this seriously, you can just look at a recent case where the NSA was sued by, I believe it was the ACLU. And that was the main issue that they raised, that they hadn't shown standing. They couldn't show a personal injury. Well, standing applies across the board, even in civil traffic cases, because we know that the government was established to what? Protect and maintain individual rights. So that's what the jurisdiction is limited to. So there is it's been a very effective way, and it shows you that no traffic ticket has any validity whatsoever. So in the next video, what we'll discuss is how to impeach a witness, which is typically in a traffic case, you only have one witness, it's the police officer. And I can go through how you can impeach him by asking only 2 questions. Some cases, you ask him even 1 question, and the judge would be more than happy to say he's incompetent to testify. But that's in the next video. Until then, I'm Mark Stevens. Go to my website. It's adventuresinlegalland.com. Hi, I'm Mark Stevens, author of Adventures in Legal Land, and this is part 2 of beating civil traffic tickets. And what I'm going to discuss today is how to impeach a witness, a government witness, by asking only 2 questions. And typically when you get a traffic ticket, the only witness against you is a police officer. It's just basically your word against his. And as the accuser, see, a lot of people may say, well, these questions aren't appropriate for the police officer. Well, that's just going in and showing that the officer's not competent to testify. He wrote the ticket. He's supposed to be able to answer questions, and you're supposed to have a right to confront your accuser and demand the nature and cause of the charge or proceedings. And you're supposed to be able to question the police officer or any witness on prior testimony, whether it's written or oral. And what he puts on the ticket is written testimony. He's making an allegation against you, and you're supposed to have every right to confront him and question him on that. They don't like you to ask questions because, as you'll see, it's very easy to show that the officer has no idea what he's talking about. They don't teach him these things, and even if he could answer the 2 questions, it doesn't help him. It just digs a deeper hole for them. And to show that, I want to just restate, from the last video, why you have government, because it forms the basis of the questions. And the public relations is, and we know this is all bull, we know this isn't true, but it's just propaganda, is that the government was created to protect and maintain individual rights. And you can find that in several state constitutions and the Declaration of Independence. So from there, we know that the jurisdiction of the court is, of course, limited to protecting and maintaining individual rights. Therefore, for there to be a case or controversy, as the courts have consistently held, there has to be the violation of someone's rights and damage. So the police officer, like everyone else, is required to file a valid cause of action, because without a valid cause of action, there is no standing, and the court acquires no subject matter jurisdiction and cannot proceed against you, or anyone for that matter. So the question is to have him impeached, and what I mean by impeach is just to show that he's legally disqualified from testifying, that his testimony is inadmissible against me, you, or just whoever happens to be the defendant in that case. It doesn't mean he's removed from office, though that would be really good. That would be spectacular. However, that's not what it means. It just means he's not qualified to testify, and legally the judge has no discretion to accept his testimony, so it's got to be thrown out, and including his prior testimony, which would be the ticket. So the two questions are this. I like to give the police officer a copy of the ticket. I'll hand him a copy and ask him, did you file a valid cause of action against me? Now, of course, he's going to have to say yes, and they usually allow him to answer that question because it's pretty obvious. If he doesn't have a valid cause of action, there's no standing, and the court has no subject matter jurisdiction, and the case has to be thrown out because the court is established to protect and maintain individual rights. It's the second question to follow up that will cause usually both attorneys representing the police officer to jump out of their chairs. And the question is, how many elements are in a valid cause of action? And usually his attorneys will jump out of the chair yelling, objection calls for a legal conclusion. The witness is incompetent to testify. Now, he could say he's unable to testify. They'll say it's outside the scope of his expertise. It means the same thing. He is not qualified to testify to those matters. But they allowed him to answer the first question. That's okay, because it helps their case. But once you ask him to explain what he said, now they've got a problem with it. What they don't understand is that the judge will always sustain the objection, which is exactly what I'm looking for. Which means the witness is incapable or unable or incompetent to testify, which now requires the judge to strike all the testimony. And it's that simple. Doesn't mean the case is going to get thrown out, because again, traffic courts are scams ran by criminals. Yeah, they wear robes, they wear suits, but they're criminals nonetheless. But it's just that simple to be able to impeach a government witness. Hi, I'm Mark Stevens, author of Adventures in Legal Land. My website is adventuresinlegalland.com. And this is Beating Civil Traffic Tickets, Part 3, The Impossibility of a Fair Trial. Well, but I do have to warn you first, there is some government propaganda here that we're going to have to go through. That's one of the ways of showing that you cannot get a fair trial, though. See, those who are looking to steal your money, the guys who are doing business as a government, mainly, say, a traffic court in this case, desperately want you to believe that you can get a fair trial. They'll even tell you that if you ask them. And I have things in here that says, an independent and honorable judiciary is indispensable to justice in our society. There is also, a judge shall perform judicial duties without bias or prejudice. That's, of course, in the canons here in Arizona. It's pretty similar no matter where you go. And of course, even bureaucrats in Canada trumpet the same propaganda. Quote, any person charged with an offense has the right to a fair hearing by an independent and impartial tribunal. That's the Canadian Charter of Rights and Freedoms. Something tells me that charter doesn't include the right to be left alone. Well, you may be saying, how is that propaganda? That sounds pretty good. Everyone's supposed to be entitled to a fair trial. Well, it is nothing more than propaganda or public relations to make you believe that you're entitled to a fair trial, but that's impossible for them to give. And one of the ways to show that, of course, is that there's no such thing as an independent and impartial judiciary. Very simple to prove, and that's what we'll go through today. See, the technical term is conflict of interest, to show that there is a impermissible conflict of interest. So let's say you have a ticket and unfortunately you have to go to court. So you ask the judge a series of questions that will show that there is a conflict of interest and that a fair trial is impossible. And the first question is simple: am I entitled to a fair trial? Now, of course, most judges are going to say yes, because, of course, that's the public relations, that's the propaganda. They have to make it look good while they're stealing your money. So now the judge is locked in. He says I'm entitled to a fair trial. So, of course, my next question would be, can I get a fair trial if there is a conflict of interest? Well, this is obvious even to us non-lawyers, and every judge that I'm aware of has always answered this question, no. that you cannot get a fair trial if there's a conflict of interest. Now, this last question I like to call the knockout question, and I call it that because it's really the only question that needs to be asked in order to prove that traffic courts are scams run by criminals. Now, the question is, and this is of course to the judge, who do you represent here? And, that's the same as asking who the judge is acting on behalf of. I gotta tell you, and you can imagine, judges just hate to answer that question, and those who think the system is valid, boy, they hate to answer this question also. Now, most judges will not answer this question, and with good reason. This one simple little question exposes their entire scam. A fair trial is impossible. And don't make the mistake of thinking that this is not a very serious issue that they, at least in their propaganda, take very seriously. And look here, it says, in all trial court proceedings, a judge shall disclose on the record information that the judge believes the parties might consider relevant to the question of disqualification, even if the judge believes there is no actual basis for disqualification. But you see, most judges will not answer this simple question. Even though the law says that they shall disclose on the record the information, they will not do that. That's because they don't want their little scam to be exposed, especially the rest of the people in the courtroom, because they may grab their wallets and run out of there, as they should. See, they refuse to answer the question and tend to get a bit irritated because it's what I mentioned before. You're bringing up the fact that there is a conflict of interest, showing that a fair trial is absolutely impossible. Because you see, judges represent the state, which is the pretended plaintiff in a traffic case. Think about that for a moment. The judge is actually representing a party to the action. You still think judges are fair and independent? Well, let's look at some evidence. This is actually from a real case in the East Mesa Justice Court. This is actually one of the very few times a judge has been responsive to this simple question. You'll understand in a moment why they typically do not answer this question.
Also, who do you represent here? Who do I represent?
Yes.
I represent the state of Arizona.
Well, there you have it. A judge admitting he represents the state of Arizona, which is supposed to be a party to the action. Gee, talk about a conflict of interest. The judge is actually representing the party attacking you. Do you still think you get a fair trial from these guys? See, common sense dictates that if a judge is acting on behalf of a party, a fair trial is not possible. And that's how to prove the impossibility of a fair trial.